This is the face of a pro-per litigant hater. Yeah, this guy here. Justice Louis. Well, let me tell you something. There's nothing honorable about this idiot right here. Okay? He's an idiot. Period. Here's the other one. Hofstadt. Brian Hofstadt. Another pro-per litigant hater. A man who refuses to read a pro-per litigant's opening brief. And this is Victoria Chavez. And she is just basically a pawn to these two over here. It's a shame, folks, but these people who claim to be intelligent and Harvard educated are not intelligent whatsoever. You know, intelligence is something that makes you aware of where you need to be on your thoughts and your character in life. And if you are not intelligent, you know, learning what's written in books in school and in college, university, that does not make you intelligent. Period. Intelligence is something that you cannot learn, or rather memorize things and write exams on those things you memorize. However, when it comes to intelligence, intelligence is not memory. You have to understand that. So here you have three stooges that obviously have no intelligence. And that is very evident. And you have to understand the difference between memory capable and intelligence. You can really teach a chimpanzee to play the piano. That's been proven. The intelligence of the chimpanzee compared to humans is obviously a huge difference. So intelligence, these people do not have. Period. When you have intelligence, the first thing you learn is respect for others, as you would respect yourself. These three don't have that attribute. It's an inconducive comportment, hurting other people and creatures that you should know is totally illicit when it's unwarranted. Of course, we're not talking self-defense here. We're talking about these three stooges, or four of them, that is in powerful positions and using those positions to judge, to make decisions when it comes to people's lives. And when there's death involved, you have to be very, very, very certain of the decisions you make. You cannot just throw around these decisions and not intelligently think about the consequences of those decisions that you just throw out there. And it's very unfortunate that these three or four do not have this type of intelligence being in these powerful positions. It's alarming. It's downright scary. The safety of many people that can die or get injured seriously, that can affect the rest of their lives. How do you sleep at night when you make decisions in favor of money rather than life? It beats the hell out of me, folks. But we're going to talk about a case today that's exactly that. And that is the Donda West law, Kanye West's deceased mother's law. So let's get into it. There's another stooge who is in the trial court, the Superior Court in California. His name is J. Ford III. J. Ford has many, many complaints, and he's another hater of pro-per litigants. Oh yes. And they are one big happy family looking out for each other. And by acting in that manner and having that kind of attitude, separating themselves from the rest of the world, is a highly unintelligent notion. He thinks what he's doing is far more superior. That is unintelligence. And you can easily assume this character from these stooges because of the way they act, the way they conduct themselves. It is theatrics that creates these flawed characters that you see here before you. These three stooges, well, including the fourth one, they are so corrupted by their theatrics, they believe they are gods, and that is highly unintelligent thinking. Another sad day for jurisprudence in the United States. These people calling themselves judges basically abuse discretion. Depending on how they feel is what they rule. We're going to talk about a case that is extremely disturbing, and these three stooges on the Court of Appeals and the stooge in the Superior Court in California, J. Ford III, a hater of pro per litigants with a string of complaints against him. The other three stooges, of course, number one on my list, the biggest stooge of them all, Justice Louis, who hates pro per litigants as well. Victoria Chavez, who I observed rolling her eyes during a oral hearing at another pro per litigant, rolling her eyes at her. You know, it's disgusting. It is very disturbing. They will put jurisprudence aside, their oath sworn to office aside, simply because they hate pro per litigants. You know, the country should be disturbed by this, because when a person cannot afford an attorney, the Constitution asks that to be respected, that a person or citizen is totally entitled to be heard and to be judged according to the laws, period. Now, we all know that they have complicated the court rules so much that it's virtually impossible for pro per litigants to follow all these court rules. But in this case, the pro per litigant was extremely diligent. And you know, I've assisted some pro per litigants through the years, and you know, when they don't have monies to afford an attorney and they seek justice, what are they supposed to do? Are they supposed to simply not seek justice? Why do these judges hate pro per litigants in this manner so much that they are willing to put the law aside just because they hate the pro per litigant? Why hate pro per litigants? What's important by the end of the day, or should be, is justice according to our laws created by the legislators. And I look at pro per litigants, they're going into a field that they do not know anything about or much about. And then they study themselves very hard on the laws pertaining to their specific situation. And then because they cannot afford an attorney, they present the case themselves, only to be stonewalled by these idiots to a degree of disrespect that leaves me nauseated. Louis, Chavez, Hofstadt, they creep me out. These people are criminals as far as I'm concerned. When you deny people their basic human rights, that makes you a criminal, period. It's like kicking a dog, which nobody should be allowed to do. But these people do. They are not honorable at all. To call them unintelligent is an understatement. In this particular case, they know they are wrong, and they know it well. How can they not know that they are wrong. But their unintelligence will not allow them to do the right thing in accordance with the law. They are more interested in retaliating against the pro-per litigant than doing what they're getting paid for, and that is to apply the laws of California as they are supposed to and be honorable. I cannot call them honorable. I'm sorry, but I cannot. Because they, in deliberance, put the law aside just to retaliate against the pro-per litigant. It's disgusting. Let's talk about this case. The pro-per litigant filed the case in the Superior Court first. And of course, Judge Ford, he never read her complaint, which is obvious, because she's pro-per. He rather read a demurrer filed by counsel for the defendants. And his whole order reeks of deception, that he did not read the complaint, but rather copied the demurrer and word for word in some instances. Because he trusted the counsel knows more than the pro-per litigant, so why even bother to look at the pro-per litigant? And counsel made sure, and counsel was Matt Sitchy, who made use of the situation very quick, knowing that she was pro-per. So, in the light of she's pro-per, berated her complaint, calling it unintelligible and confusing. That's what you do when you have no defense. You call the complaint indiscernible, not understandable, cannot understand, that sort of thing. And Ford obviously just bought into that, hating pro-per litigants himself with a string of complaints against him, and dismissed the case, but rendered an opinion nevertheless, as this opinion he copied from the demurrer. Then she went to the appellate court hoping that she would get justice there, only to be faced with the same scenario. You got three stooges sitting there backing up Judge Ford and denying 9 motions. Louis denied 9 motions of this pro-per litigant, and I read those motions, and they were all perfectly in line with court rules and legislation, and all should have been granted. All of them. He rendered no opinion of why he denied the motions. He just denied them, except one motion that he stated that the court cannot consider any additional evidence that was not presented in the trial court. He is right with one exception, and that's Rule 901 amended, that states specifically that if the appellant waived a jury trial, and whether or not the case was, she is entitled to present more evidence so that the appellate court can make an informative decision to dispose of the case in an informative manner. So she cited Code 901, and Louis ignored it. I'm sorry, but the man is pathetic, and I say that with no reserve. And basically a man that should be not in the position that he is. Now, he loves doing his thing around people of his peers, but he hates pro-per litigants. How dare pro-per litigants come in and tell us what to do? Well, he denied 9 motions this way. That was the only one he stated an opinion, and he was wrong. And she asked him to reconsider that motion and pointed out to him that he was wrong, and then he simply just denied it again. So after 9 refused motions, it became clear he was a pro-per litigant hater. So she filed a motion to recuse him, and he refused, of course. No honor whatsoever. So then she had a hearing, an oral hearing. She hired an attorney, an appellate attorney. The appellate attorney was terrible. She, of course, did not study the case properly. She never prepared the briefs or wrote them. She thought it was a simple, easy case. And it should have been a simple, easy case, because the law is clear and simple, easy to understand. But then she was given a question by Hofstad that was shocking to me, that the man who calls himself a judge asking such ridiculous question was shocking to me. And I thought, you know what? It's clear they never read the briefs of the appellant, but they did read the answer brief from counsel. Again, same scenario. It's disgusting. It is disgusting that this is going on in our courtrooms, that these clowns are sitting there demanding respect when they are nothing but violators of the laws of California that they are supposed to uphold. They basically, in the end, handed plastic surgeons a license to risk the lives of patients found not medically cleared. In the face of the Donda West law, the Donda West law, so named after Kanye West's mother, is a prevention of death law, clear in its instruction to plastic surgeons and governs them notwithstanding expressly. No other law may supersede the Donda West law when it comes to the issue of when and when not a plastic surgeon may move forward with plastic surgery on a patient. In this case, the patient suffered a blood clot. She suffered high blood pressure and spontaneous broken ribs due to her osteoporosis condition, and had many other ailments. She signed a contract, and these plastic surgeons reserved a spot for her and have a patient cancellation clause. This patient cancellation clause may not withstand the law's instruction that expressly governs them, period. The Donda West law does not allow for any such exceptions or provisions. It states unequivocally, the plastic surgeon will be barred. He is prohibited from performing the surgery on the patient if the patient is found not medically cleared by any qualified physician. Any qualified physician. That is key. These stooges stated in their opinion that Kenneth Hughes from Elite Plastic Surgery was entitled to examine her himself. The law says no, and there's a good reason for that, because plastic surgeons are greedy. They're in it to make money, and thus will take risks on patients' lives. Kenneth Hughes already has 3 deaths under his belt. He was exonerated for 2 of them by the medical board, nonetheless, and some injuries that he caused. But one of these deaths, a woman with high blood pressure, was settled in some way or form because I cannot find the outcome of the case, which normally means the case was sealed after it was settled. The Court of Appeals was aware of all of this, and they just ignored all of it. So when this pro-per litigants doctors notified Kenneth Hughes by fax that they found the patient to be not medically clear, she rushed to the emergency room where they found her ribs broken spontaneously and the blood clot and the high blood pressure, and notified Hughes right away. She, on her way home, or when she got home, called him and asked him if he received the fax. He said yes, but she should ignore her doctor. Oh my God. He said explicitly, you can always ignore your doctor, and if it was me, I'd do it anyway. And by the way, if you do not show up for the surgery, we will not refund you the $24,000 you paid us. And that was for 6 surgeries he wanted to do in one day. Her doctor asked him for 3 months. He requested 3 months, without exception, to reevaluate her, which would have put her not medically clear well beyond the surgery day. And Hughes is telling her, get on a plane in South Carolina, fly to Los Angeles with broken ribs, a blood clot, high blood pressure, and your other ailments you're suffering from, and she now has skin cancer as well, and fly to Los Angeles and be here on the surgery day. I don't care about you're not medically cleared. I don't care if you will die under anesthesia because of your high blood pressure and blood clot that can go through your heart. I don't care. You be here or you will lose your money. The Donda West law does not make provision for that. Does not allot a plastic surgeon to make demands like that. It tells the plastic surgeon, it instructs the plastic surgeon, you may not. Thus, essentially, the Donda West law forces a breach of contract on the plastic surgeon. That means the plastic surgeon cannot provide his services because the law is prohibiting him. Yet, he's got a patient cancellation clause attempting to override the law by her giving him permission to violate this prevention law and go to California and say, sure, go ahead, I'm aware of the law, Dr. Hughes. However, I'm giving you my consent to do it anyway. And under that guise, Hughes apparently believes he can do it. The law's instruction is not to the patient, it's to the plastic surgeon. It's his responsibility to make sure she is medically clear. The law instructs him to do that. Yet, During the verbal argument, you have got the idiot, Hofstadt, asking the stupidest question, isn't it the patient's responsibility to get medically cleared? And what's that got to do with the contract if she's not medically cleared? That shocked me to my core. When I watched that verbal hearing, it shocked me. And I knew that this stooge did not read the opening brief of the pro-per litigant because he's not interested. They were attacking her immediately. Then the attorney Sitchi also misconstrues and misrepresent and saying that the issue of her being medically cleared was never answered, which is a lie because the exhibits clearly showed her doctor declared her not medically cleared, which makes the question of her being medically cleared or not answered. Later, he is attempting to say, after the court's decision, that he meant Hughes did not answer that question. Well, the appellate court stated that Hughes was entitled to examine her personally, which the law also does not provide for. The court therefore provided false and misleading authority, citing the Donda West law, giving that authority to examine the patient themselves, which is not true. It's not there. It's made up. Judge Chavez Stooge used the Donda West law. She cited the Donda West law, allowing Hughes entitlement to examine the appellant himself, which is completely false. That statute says nothing about the sorts. Nowhere. It says any qualified physician may make that determination of medically cleared or not. Yet Chavez says Hughes was entitled, with no authority backing that statement up. And that's for good reason that the Donda West law states any qualified physician, because the legislators knew plastic surgeons are greedy and they will take chances on patients' lives. So they are giving the patient the option to go to any qualified physician that does not have a monetarily agenda. And if any qualified physician finds the patient not medically cleared, the plastic surgeon must adhere to it. Now, nowhere in their briefs do respondents make argument that they did not trust her doctor's opinion. And then a specialist also confirmed that this patient, this appellant, was indefinitely not cleared for plastic surgery due to her chronic ailments. Yet, the appellate court says Hughes may use a patient cancellation clause and force her to show up for the surgery or lose her money. That is extortion. You better show up or lose your money, in the face of her not medically cleared, in the face of the law prohibiting him from performing the surgeries. Yet, Court of Appeal says that's all fine. It's all fine that he threatens her. It's all okay. These three stooges are so off their rocker, it's nauseating. And I know why they're off their rocker. Because they hate pro-per litigants. They don't want to publish this case. Of course they don't. Because they know they're wrong. The lawyer in this case was unethical. In many instances, he says things that were off the cuff, insinuating things, and it's all wrong. He claimed the Donda West law is basically non-important, when it's the very law that expressly governs contracts between plastic surgeons and their patients. It is a problem, people. It is a problem. Now, she is attempting to get to the Supreme Court of the state, which they only look at 3% of cases they get. So, how to make the Supreme Court aware of this detrimental questions in the face of death? You know, she actually considered caving in. And then she thought, there's no way, it's impossible. And that, raises all the impossible doctrines. The doctrine of impossibility, the force majeure law that demands a force majeure clause in a contract that is considered a quasi-contract. Now, this quasi-contract is a contract expressly contingent on the law, such as in this case. A quasi-contract demands the law first be satisfied that it's contingent on before the agreements between the parties can be considered, such as a cancellation clause by patient. The patient did not cancel this, the law did. So imagine a patient caves into those threats because the patient does not want to lose her $24,000. It's a lot of money. And so the patient actually goes and shows up with high blood pressure and a blood clot. And then the patient dies. Countless patients die because of unethical plastic surgeons such as Kenneth Hughes, perfectly willing to take a chance on their lives for monetarily gain. Greed. And the state of California is going to be faced now with even more wrongful death suits. Okay, that's the next step. So she dies after the plastic surgeon forces her to do it and violates the Donda West law. So then she dies and a wrongful death suit is filed. What good does that do? What good does a wrongful death suit do when the patient is dead? There is clearly a law to prevent this wrongful death suit by making sure the patient is not going to die by barring the plastic surgeon from performing the surgery. The appellate court says, oh, no, it's all fine. Their contract is proper. In those words, their contract is proper, their cancellation clause is proper, and it's proper that they tell the patient, ignore your doctors, show up, and if you don't, you lose your money, and do it anyway, regardless of not being medically cleared. Those are the exact words of Kenneth Hughes. They never ever denied him saying those words. It's bold, you understand? And this appellate court is bold as well, because they think they're gods and they think they're untouchable and they can do as they please and they can distort law as they want and they can ignore law as they want and they can make up law as they want. Let me tell you something. That's what makes this country so dangerous when it comes to our courts hiding under the guise of protecting you. Because we have jurisprudence. We've got laws that protect the public. It's a guise when that's not the case. These three stooges, including the fourth stooge, are an abomination when it comes to jurisprudence involving pro per litigants. Disgusting. Now Chavez wrote the opinion and the other two stooges concurred. How can they all three make this mistake? How is this possible? I'll tell you how this is possible. They hate pro per litigants. They don't care whether people die. They creep me out. I watched their demeanor during the oral hearing, and frankly, it sent chills down my spine. They seemed heartless, robotic. Their hatred for the pro per litigant was so obvious. Shame on them. Shame on them. They are pieces of shit. The law and rules of court, they don't care. They are disgusting. Chavez, she's just a pawn. She's a pawn to Louis. And Hofstad, a hater of pro per litigants as well, renders him a complete idiot. So this is what we have. We have a country that hides behind the guise of jurisprudence, and all the while these judges are tyrants. They are unethical, they are corrupt, they look at themselves as family, and you are beneath them. You are not worthy to be a pro per litigant in their courtroom. When the law is clear, they don't care. When a motion is clear and within the rules, their rules, you are pro per, you lose. It makes me sick, people. It makes me sick. So now, because of this ruling or opinion, more patients will die, because now the message is clear from the Court of Appeals. Ignore the Donda West law by using a patient cancellation clause, forcing patients to show up or lose their money. This law is asking for a patient to be medically cleared not outside of 30 days and up to the day of the surgery confirmed. Her physician confirmed she will not be medically cleared on the day of the surgery by requesting 3 months to reevaluate her. Ignored by the Court of Appeals that says that Kenneth Hughes from Elite Plastic Surgery is totally in order by threatening her to show up or lose your money, and that the Donda West law is really not important. I wonder how Kanye West will feel about that. His mother is dead because no such law existed then. Now it does. But now that law is being ignored. Yet this law says it's notwithstanding, it's in effect prohibiting plastic surgeons from doing surgery on a patient found not medically cleared by any qualified physician. So there you have it, folks. Now Hopefully the Supreme Court will take notice. I expect better from the Supreme Court. I really do, regardless of whether she is pro per or not. But what I do expect really is them simply denying the case because they can't get to it or they're not interested in looking at it, specifically because she's pro per as well. It's disgusting. It's disgusting what's going on. How do these people sleep at night? I don't understand. How do they sleep at night? Jurisprudence does not matter when it comes to pro per litigants. You know, it's up to the people to do something. Share this video. Share it. Every time judges are corrupt, they get paid by taxpayers and they do not belong where they are. The majority of them are just simply corrupt and criminals themselves. Hofstad, Chavez, and specifically Louis. He's been asked to recuse himself from this case after he denied 9 motions in defiance of the law in front of him. So they violate their own rules when it comes to pro per litigants, just to get the pro per litigant out of there. Oh, we hate these pro per litigants so much that we will put aside our sworn oath to office to uphold the laws of California and the Constitution. It's a shame. And these 3 stooges, including Ford, the 4th stooge, have basically affirmed they are not honorable at all. Please share this video. These people have to be exploited. When people can't afford an attorney, the Constitution says they can defend themselves. That needs to be respected and adhered to. So please share. Thank you.